Okay. You can begin the proceedings. Mr. Del Basso, we're ready to begin. We're going to start with the fourth case. Good morning. Welcome to the Board of Liquor License Commissioners for Baltimore City's AM docket. Today is Tuesday, August 4th, 2020. The board will be hearing violation cases today. This is just a brief PowerPoint presentation. There's an outline of the packet. And for all of those who are watching online, please click on the link if you want to participate in the meeting itself. There's the access code and the password. If you do not have an iPhone or computer or other similar device, please use the phone number and access code below. You will only be able to listen in on the hearing if you use just a phone. Next, materials, evidence, and related items. All the materials, which comprise a short and long docket, can be found on our link for the August 4th, 2020 hearing. We receive evidence approximately 48 hours before all these online hearings, and that evidence is received by Ms. Russell, who we then forwarded to the board. Pardon me, licensees and related items. Licensees should make all efforts to provide any documentation that they plan on submitting forward by 11 a.m. on Sunday, August 2nd, 2020. Attempts to introduce evidence at the hearing that was not submitted prior to the hearing date and time may lead to postponement of your case. Procedures for the docket: there'll be a preliminary reading of the instructions, and then I will call the cases. Second will be an evidentiary hearing, and this is where the board takes facts and information both from the inspectors and the licensees. They may have questions after this proceeding. The board will then ask if there are any members of the general public who wish to provide testimony. If they do, they will be sworn in, provide testimony, and then the board will render its decision. Just some general ground rules. You want to speak slowly in a clear voice. When you are giving testimony, identify yourself for the court reporter. These proceedings are recorded. And then all attendees, please be mindful of where you're located if you're using your video footage. You want to make sure you're in a well-lit area and your audio is on and working. With that, we will jump into the docket. And since we have Mr. Gentile present, we're going to move right ahead to case number 4. This is Scott Donnelly, Mark Gentile, and Tim Wisted, Havana Management Incorporated, trading as Little Havana, 1325 Key Highway. This is the Class BD7 Beer, Wine, and Liquor License. A violation of Rule 3.12, General Welfare, on May 29th, 2020. Board's indulgence, I'm going to be bringing in the licensee as well as our inspectors. And Mr. Gentile, I'm bringing you on. If you could please turn on your video and audio. Agent Perez, I have you here as well.
I believe I'm on.
Yep.
Okay.
We see you, Mr. Gentile.
Good morning, everybody.
Morning. Can we have the reporter swear them, please?
I see Mr. Gentile. Okay, and Mr. Perez. Would you please raise your right hand? Thank you. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth to help you God or under penalty of perjury?
I do.
Thank you.
Thank you. Good morning. Mr. Gentile, I'm the chairman of the board. You're charged with a violation of Rule 3.12 on May 29, 2020. Do you wish to admit or deny the violation?
I admit the violation.
Okay. I see from the record that there was no one from the licensees present at the time. Do you want to tell us what was going on?
A according to what I've read, like you said, I wasn't there, so I'm taking it at its word. We have a exterior speaker system set up that's run on a timer to stay within the guidelines. At some point, we lost power, I'm assuming, and the timer. I actually submitted a picture of the timer via email. I don't know that it's important.
Mhm.
But the timer got out of whack with the actual time or something to that effect. Or maybe it just was off and the music stayed running overnight. I didn't actually hear about that particular violation. It was a few nights later that I was at work, and it was around 11 o'clock, and we had inspectors show up and say the music's still on. I shut it off. I realized that we had a problem. They told me that we'd had a previous violation, and that was when we removed the timer, and we've since either operated the music manually or just we really don't use it right now until we can get a better timer and figure out the situation.
Okay. I would suggest that if you are going to use the time, what time is it supposed to go off?
9 o'clock.
So if you are going to use it, you're going to have somebody check it to make sure that it's working properly. You understand?
Oh, I do.
Okay. So you've had this license for about 5 years, and according to our records, this is your first violation. Have you been open during the pandemic?
Just to clarify, we've been in operation now 23 years. We switched to this to this license 5 years ago.
Right.
I don't know that we have a violation in all that time. We were closed from approximately May 20th to approximately the 5th of May, and we reopened after that. I don't know the exact. Actually, it's written on the screen, isn't it? So the violation was at the end of May.
Yes.
And we were still definitely trying to figure things out at that point. There were a lot of balls in the air, and I guess the music got overlooked.
So you closed in March, is that what you meant?
Yeah, we closed, I would say, around the 20th of March.
Okay. All right, well, thank you. Do the other commissioners have questions for Mr. Gentile?
I think Commissioner Guy's muted. I have no questions.
Mr. Guy, you've been unmuted. Commissioner Guy.
Oh, okay. No, I didn't have any questions.
Okay, thank you. Mr. Akras, is there public comment?
If there are any individuals that would like to make public comment on this case, Little Havana, 1325 Key Highway, please use the raise your hand function at this time. Mr. Chair, I see no individuals that wish to give testimony in this case.
Thank you. Mr. Gentile, then, based on the evidence that was submitted with the charges before the board, as well as your testimony and your admission, I would find a violation of Rule 3.12, General Welfare, on May 29, 2020. I take into consideration the fact that under this current license, this is your first violation, and the unique circumstances that you're faced with during the pandemic. So I would, as a sentencing, impose a $250 fine, and I would give you 30 days to pay it.
All right.
Commissioners?
Yes, Commissioner Guy. Also, in consideration of the testimony and evidence presented to the board in this case, I also find that the licensee is in violation of Rule 3.12, General Welfare. It took place on May 29th, and I concur with the fine.
Thank you.
Agent Perez, I assume they were cooperative?
I didn't get a chance to talk to them.
Okay, all right, thank you. I too find a violation of Rule 3.12, General Welfare on May 20, 2020, and, excuse me, and would concur with the imposition of a $250 fine.
Ms. Russell?
I'd like to call exhibits for the record. Exhibit number 1, investigation report, Agent Clark. Board Exhibit 2, 311 complaint database printout.
Okay, thank you all. Good luck to you, Mr. Gentile.
Could I make a comment?
Man?
I'm
Yes.
sorry, I didn't hear you.
I said you may.
I feel like I'm quibbling a little bit, but we're real strapped right now. Anytime it rains like this, we're obviously closed, and we are barely making it, barely paying our employees at this time. I realize $250 isn't a lot, but if there's any chance of getting it waived, I would appreciate it.
Well, I think we have to impose a sanction. Normally, on a first, you impose twice that much. So I would stay with this sanction, but I appreciate your circumstances. I hope that you can get yourselves open soon.
All right. I thank everybody.
And Mr. Gentile, we will be mailing you correspondence with the board's decision and information.
Understood.
Thank you.
Am I signing off?
No, I've got you. Sorry.
Okay, thank you.
Mr. Chair, I see a number of people have logged on during our conversation, or during the discussion of the first case. With your indulgence, I just want to check some people in, okay?
Please do.
Mr. Previs, are you there?
Yes, can you hear me?
I can hear you, Mr. Previs. Mr. Previs, now if you could let me know, Mr. Previs, what cases you are here for.
Okay, I have number 2, Eminem Lounge.
Yes.
Number 3, Q's Liquors.
Okay.
And number 5, Jackson Munoz.
Okay. All right. I will, Mr. And are all your witnesses present? I'm just going to check to see if your witnesses are present, okay?
Hughes is here, Eminem is on his way, and Jackson is in the lobby. The issues on Eminem and Hughes are identical, and it's more of a legal argument, and I just emailed you a memo that I would ask the board to hold sub curia and consider. It has to do with the constitutional challenge to the House Bill 954. So we could do those together.
Okay, I understand. So you're saying all of your witnesses are present with you for case number 2, 2500 Biddle, and case number 3, 2521 East Monument Street.
Case number 3, they're here. Take case number 2, the licensee's not here, but I can go forward without him. It's a legal argument.
Okay. I'm just, Mr. Chair, I'm just going to check in a couple more because I think there were 2 or 3 inspectors on this, and I wasn't able to check them in prior to, so just give me 20 more seconds.
Go ahead.
Inspector Chase, or what case are you here for?
I'm here.
Inspector Chase, which cases are you here for?
Eminem.
Okay. Got it. Got it. Okay. All right. I'm going to bring everybody in now, and we'll start with, since I believe Hughes is present, we'll start with case number 3.
Okay.
Agent Clark, which case were you here for?
Sir, I am here for Eminem, Young's, Q's, Little Havana.
Okay. We've already got Little Havana. Okay. All of those have been made a panelist. And I'm pulling in the chief and making the chief a panelist as well. I believe all of our witnesses are present. And Mr. Previs has been made a panelist. And we can start with case number 3 because that's the case Mr. Previs said his client is present for, which would be Q's Liquors.
That's fine. Okay.
Is that correct, Mr. Previs?
Yes, can you hear me still?
Yes. Previs, would you identify yourself for the record, please?
Thank you, Mr. Chairman. Peter Previs on behalf of May Han, PR on behalf of New Q's Liquor and Tavern, Inc., trading as Q's Liquors, 2521 East Monument Street.
Before we begin, I just want to call the case for the record. Mihan Personal representative, New Q's Liquors and Tavern Incorporated, trading as Q's Liquors and Tavern, 2521 East Monument Street, the Class BD7 beer, wine, and liquor license, a violation of Alcoholic Beverages Article 12-2005C3 on July 10, 2020, a violation of Alcoholic Beverages Article 12905D3 on July 10, 2020, and a violation of Rule 4.05 prohibited hours, July 10, 2020.
Okay, can we have the reporter swear all the witnesses, please?
Okay, would you be able to turn on your videos? Okay, I see Mr. Clark. Ms. Chase, can you turn on your video?
You press them on, turn on your video if you have one. Inspector Jordan.
I just don't see everyone yet.
There's, I see the chief. Come on. Inspector Jordan is there.
Okay, yeah, I see Jordan, Cosmelos, and Clark. And just not Mr.
Yeah.
Okay. All right. Would you all raise your right hand? Thank you. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, to help you God, or under penalty of perjury?
Yes.
You can just each say your name and then say. Thank you.
Yeah, I do. Inspector Trace, I do.
Rosalba Jordan, I do.
Agent Perez.
Thank you.
Yeah.
Okay, do we have everyone then?
Yes, everyone's been sworn in.
Okay.
Witnesses are present.
So, Mr. Previs, as you know, your client's been charged with 3 separate violations on July 10, 2020. I heard you say earlier that you have submitted a legal memorandum challenging the constitutionality of the statute. And I don't really believe that the board is likely to take that up, but you may certainly make that a part of the record. For purposes of our hearing, does your client wish to admit or deny the violation?
I don't wish to admit the violation, Mr. Chairman, but I do wish to stipulate to the facts.
That's fine. Okay.
Okay. And with regard to the board's authority to hear the constitutionality of the record, in the memo, I did cite the case of Insurance Commissioner of Maryland versus Equitable Life, 339 Maryland 596, 1995, Judge Eldridge, indicating that the insurance commissioner is obligated to hear the constitutional issues. And under Prince George's County versus Raised Used Cars, Judge Eldridge again, that it is the obligation of the respondent in administrative proceeding to raise those issues at that level.
I don't have any problem with your raising them or us hearing them. So if you wish to put something in the record on it, go ahead.
Okay. I've submitted a memo. It's self-explanatory. I do want to go over what I put in the memo for the board's consideration. and ask that that be made part of the record. If I could just explain the basis of the arguments a little bit, Mr. Chairman, I would appreciate that.
Go ahead, and the memo will be made part of the record.
Thank you. All right, the first argument with regard to the constitutionality of House Bill 954 that was passed in March of this year at the very tail end of the legislative session. Initially, there was Senate Bill 328 and House Bill 954 was its companion. And those bills had to do with the allowance of exchanging a Class B liquor license for a Class BD7 liquor license on the block, the 1200 block of Charles Street. That's all that bill had to say. That, in the Senate, that was introduced by Senator McCray. There was another bill introduced by Senator McCray, Senate Bill 571, that had to do with these restricted hours in this basically rectangle north of Hopkins Hospital and south of North Avenue that is at issue at hand. That Senate Bill 571 made its way through the Senate and did not make its way through the House, and it died. The very tail end of the legislative session, after Senate Bill 328 had passed the Senate, passed the House, and came back to the Senate for amendments, Senator McCray added on to House Bill 954, the amendment including Senate Bill 571 and another bill, Senate Bill 824, that was meeting a similar fate that had to do with creating a Class C license, and made an amendment on the Senate floor. No discussion whatsoever, no explanation whatsoever, other than Senator McCray indicating, quote, this bill simply amends to add on two bills that was already heard, passed out of the Senate chambers onto the Senate bill, onto House Bills 954. They are both local jurisdiction bills and district bills, period. No discussion, anything. The bill passed with the amendments. Now, under the Maryland Constitution, Article 3, Section 29, it indicates that every law enacted by the General Assembly shall embrace but one subject. Here we have two subjects. We have initially the good part of this bill, exchanging a Class B for a BD7 in the 1200 block of North Charles Street, and then we have this amendment restricting hours. In the case of MGDOW versus State, 358 Maryland 308 2000, the Court of Appeals dealt with a situation very similar, having to do with the Corporations and Associations article. In that case, there was a bill that was going through swimmingly that had to do with the requirement that a resident agent now has to sign to evidence that person's consent to become resident agent of a corporation or other entity filed with SDAT. There was another bill that had to do with limiting directors' liabilities for investment companies, and that bill did not make it through committee in the Senate. As a result, T. Rowe Price and other representatives of investment companies threatened to pull out of Maryland if that legislation was not passed. The legislation was then added on as an amendment to the resident agent bill and passed. The Court of Appeals said they were two subjects. The state tried to argue that since they were both in the Corporations and Associations article, that they were but one subject. The Court of Appeals did not buy it. They said there are two subjects. In the instant case, it's clear that exchange of a license in the 1200 block of North Charles Street and the limiting hours of all licenses except Class B and Class C in the area north of Hopkins Hospital and south of North Avenue are two very different subjects. The court in MGDOW said that the The initial part of the bill should survive and the amendments should be stricken. And that is what we are requesting with regard to this legislation.
So House Bill 954, did that become 12-2005 or 12-905?
Both.
Oh. So the amendments included both a plenary provision that applied to all licensees as well as one that applies specifically to BD7 licensees?
No, Mr. Chairman. The first part of House Bill 954 has to do with the original subject to 1200 North Charles Street, changing out a B for a BD7. The amendment did one thing and put it into two places in the code. It indicated in 12-905 that the hours for BD7s should be limited to 10 o'clock. For other licenses, that was inserted in section 1220.05C3.
So 1220.05C3 does not apply to BD7 licenses?
The board has charged it as a violation, and my second argument, in fact, is that it does not apply to BD7s because of another amendment that occurred in the same legislative session, but is applicable under 12-905. So what happened was that the original 1220.05C has a similar time restriction for the Park Heights area, and other legislation that was passed this year exempted BD7s from that section. So as it reads now, BD7s are not included in 1220.05, but they are included in 12-905.
But
so that section, yes, sir.
Even if it did apply, it's redundant. You would agree? That means
yes, sir.
Okay. So let's focus for the moment on the second violation, the 12-905D3, and your constitutional argument would apply to that. I haven't had the opportunity to read your memorandum, so I don't know that I'm prepared to rule on the constitutionality of it. And this is going to be the same argument in 3 of our cases, correct?
Yes, I represent docket numbers 2 and 3. I do not represent number 1, Mr. Chairman.
Well, if you're right, it would apply to all 3 of them, but we didn't get the memo in time to consider it.
Yes, Mr. Chairman, I would ask that you hold the matter sub curia after you had an opportunity. It is a bit complicated. Additionally, there's a second constitutional argument in the memo, and that has to do with equal protection. And
how is that?
The area where the hours are limited, which is from North Avenue on the north, Harford Avenue and Central Avenue on the west, Monument Street down to McKeldrey on the south, and Luzerne Avenue and over to Rose Street around the cemetery on the east. The census data indicates that consists of 4 neighborhoods that are between 89 and 96% African American population. Fells Point, on the other hand, may only have 3.2% African American population. This law is a classic example of racial profiling. You have licensed establishments that serve persons in African American communities that have to go home at 10 o'clock, while in white communities can drink until 2 a.m. I've laid out in the memorandum that this First of all, there's no legislative history in House Bill 954 or Senate Bill 328 because the only discussion had to do with the license on Charles Street. If the board were to consider the legislative history found in Senate Bill 571, there was a committee hearing. The main proponent of that legislation was the Baltimore City Police Department, and officials of the Baltimore City Police Department did indicate that this is a high crime area. Well, to say that an African-American community is a high crime area is to not distinguish between African-Americans living in that community who do not commit crimes and African-Americans in the community or anyone else for that matter that may commit crimes. So it's a classic example of racial profiling, and it's no different than saying we want to pass a law that says we can stop all cars driven by African-Americans because they're more likely to commit crimes. It's just not the case. It's disgusting that the police department would ask the legislature to pass a law saying we need to close places in African-American communities earlier because they're more likely to commit crimes.
So let's go back to the violations, okay, Mr. Previous?
Yes, sir.
It strikes me that 12-2005C3 is inapplicable to this case. I also have problems with the 4.05B violation because that says that you're violating the time limits that are on your license. And this is not a time limit on your license. It's a time limit imposed later by statute. So I don't think that's applicable. But as to 12905D3, I'm not prepared to rule on it without reading your memorandum. So I'd like to ask the other commissioners, after I ask you a question, if they agree with me. Would you be willing to have the case rise or fall based on our legal ruling on your memorandum as to that violation?
Yes, Mr. Chairman.
Okay, and of course, we would then have to impose a sanction, and so I think we can talk about that too right now, and so we make the record clear of what's going to happen later on. But are the other commissioners satisfied with us taking under advisement his arguments as to 905D3 and ruling after the hearings as to that?
Commissioner Guy, yes.
So Mr. Chairman, I have a little bit of a different view on the violation of Rule 4.05B.
Okay.
And I think that's because, if I'm not mistaken, the liquor board sent, please correct me if I'm wrong, Mr. Akris, sent to the licensees a letter notifying them of the change in time, the restrictions, along with a new license with those restricted hours. Is that accurate, Mr. Akris?
That is correct. We did that a week to 2 weeks prior to the July 1st effective date.
So they were actually issued new licenses listing the restricted hours?
Correct. We hand delivered the letters describing the effects of the law, issued licenses with the new time limitations on them, and verbally explained the restrictions to them, which were imposed by House Bill 954.
So I didn't understand previously that they had gotten new licenses. All right.
Mr. Chairman, may I clarify?
Yes.
Okay, around June 26th was my first notification that this had occurred because we were under the impression that Senate Bill 571 had died. I received a call and then was sent a copy, and what had occurred is liquor inspectors hand-delivered to the affected licensees a 2019-2020 license, May 1/19 through April 30/20. And it had the new language on it saying the closing out, the hours of operation being from 9 a.m. to 10 p.m. So nobody's been issued 2020 liquor licenses at this point. They took the old 19 license and they exchange it for a new one that had
You're
that.
saying the violation occurred after that license expired?
Yes.
Okay.
And Mr. Chair, just to clarification, with the governor's executive order that was issued March 12, 2020, all license periods have been extended. So the 2019-2020 license period is still running as of this date. The license year will not end until 30 days after the governor rescinds that state of emergency. So the 2019-2020 license is the license that should have been issued and remains in effect.
All right. So I think I'm now of the view that that violation probably still stands. So I would rule subsequently as to the 12905D3, and I would rule now as to the rule 4.05B, and I'd rule on the sanctions now if the other commissioners are in agreement.
I am, sorry, Commissioner Guy.
No, I concur. I agree.
Mr. Chairman, I agree. I just need some further clarification, if I could, about why 12-2005C3 is inapplicable. Mr. Previs, can you just can you explain that to me one more time, please?
Sure. In your packet, you have a copy of House Bill 954.
Correct.
And in subsection on page 5, at the bottom, 12-2005C1, this subsection does not apply to Class B beer and wine, Class B beer and wine and liquor, Class C beer and light wine, Class C beer, wine, and liquor. There was another amendment in the 2020 legislature that added to that exemption Class BD7. It's not printed here. If you give me a moment, I can tell you what that bill was.
If I may, Mr. Previs, I believe he's referring to a House bill that was introduced specifically for the Wabash Liberty Heights corridor, which restricted the hours of a Class BD7 license from 9 a.m. to 9 p.m. That was a piece of legislation that dealt specifically with the Wabash Liberty corridor matter.
It's Senate Bill 181. It's in Maryland Laws Chapter 92, and it amended 2205C1 to include BD7s on there. Perhaps the intent, or probably the intent, was that area in Wabash, but nonetheless, if you pull up from Westlaw 12-2005C1, you will now see that it exempts Class BD7s. That's why I'm making that argument. It's more of a point of clarification, like the chairman said. If the law is constitutional, it falls under 905 and not 2005. But that's why I made the argument.
Okay, thank you, Mr. Previs.
Okay. So, Mr. Previs, in the event that we find that Alcoholic Beverage Article 12-905D3 is constitutional, based on the facts in this record to which you've stipulated, I would find a violation of that statute on July 10, 2020. We find that it wasn't constitutional, I won't. As to violation of our Rule 4.05B on July 10, 2020, I would find a violation of that now based on the new license, if we determine the new license was constitutionally sound. So if we find that there's no constitutional problem, I would find two violations. I would not find a violation of 12-2005C3. And then as to a sanction, in the event that we do find that there are violations. The sanctions should be imposed. This licensee's had the license since 1998, and in the last 10 years has had 4 sales to minors. 2 of them.
Mr. Chair, I apologize for interrupting, but there are a number of people that may want to give testimony in this matter from the community.
What I'm saying before we go there, because I can come back and revisit it, but I want to be clear to everybody where this is going to go. Okay.
Apologize, Mr. Chair.
That's okay.
Mr. Chairman, may I make one point of clarification before any final ruling or any provisional final ruling?
Go ahead.
I have provided census data with regard to my argument number 3, equal protection. I ask that the board accept a proffer that almost entirely, if not entirely, the clientele of this establishment are African Americans as well.
Well, I don't know anything about that, but what does that have to do with the prior sales to minors?
No, Mr. Chairman, I was just trying to preserve the record before you moved on.
Oh, okay. Mr. Ackers, go ahead. Let's see who else wants to talk about this.
Okay. If there are any individuals at this time who wish to provide testimony, please use the raise your hand function. I believe I see Senator McCray on. Senator McCray, would you like to give testimony in this matter? I can make you a panelist now.
Mr. Ackers, that would be appreciated.
Okay, making you a panelist now. Please bear with me. I see some individuals joined us late, so I just want to make sure I check them in as well. Mr. Thrasher, I see you've joined. Are you here to testify on this case, Q's Liquors, 2521 Monument Street?
No, I'm not.
Okay. I have Marcella. I see a Marcella. I can't read your last name. Are you here to testify on Q's Liquors? Okay, they dropped off. I see this is a caller number 5. I just unmuted you. Are you here to talk? Are you here to give testimony on Q's Liquors?
No, I'm just here to listen.
I'm sorry, say that again.
No, I'm just here to listen. Thank you.
Just here to listen. Okay. I see a caller and user number 6. Are you here to give testimony, or are you just listening in? Hello? Okay. And I'm just going through. Stephen Zerta, are you here to give testimony in this case?
No.
Okay. All right. I have pulled in then Senator McCray, and he should be online now. Senator, can you please turn on your video? Okay.
All right, let's swear the senator.
Okay, please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you.
All right, thanks, Senator. You want to address these issues?
Mr. Chair, members of the board, I just first would like to say thank you for the work that you all do on behalf of the city of Baltimore. I am the senator that was being referenced a number of times in reference to Senate Bill 571 and House Bill 954. But I would just like to go on record as stating that in November, it was a number of community leaders that actually gathered together about some of the establishments that were in our footprint of East Baltimore, my respective legislative district. And we met in November with not just the community leaders, but also the police commissioner, the Eastern District Major, and a number of stakeholders within our community in reference to the challenges that we were having around crime. And during we were able to research and take a look a number of vehicles that was possible to try to help alleviate some of the challenges that are in our footprint. The communities that I'm talking about is Berea. The communities that I'm talking about is New Broadway East, Oliver, McElderry, Park, which share a number of the same situations around a number of the establishments within our footprint. And during the legislative session, obviously, I noted it was referenced that there was the major, who was a large component, but the reality was that there were a number of community leaders who testified during the Education, Health, and Environment Committee to let them know that they were not only supportive, but working with us in order to alleviate some of these challenges. I will not continue to bear on the board in reference to the time. I just felt as though it was very, very important to elevate the community's voice in this conversation and just letting them know that there are a number of stakeholders out of those respective communities that I just talked about: Berea, Oliver, New Broadway East, McElderry Park, and Milton and Montfort neighborhood, that are just trying their best, that have a very vested interest in the city of Baltimore, specifically East Baltimore, and just looking for every avenue, every vehicle to make it as livable as possible, as walkable as possible, and a safe space for our young people and our seniors to be able to enjoy. Thank you again, Mr. Chair, for giving me this opportunity to say a few words. So thank you again to the board members.
You're welcome, Senator, and we appreciate all that, and I think we share your views about that. We have not had an opportunity to read the memorandum that was submitted. I don't know to what extent I'm going to agree with it or not. If you would like an opportunity to take a look at it, we can provide it to you as well.
I would appreciate it.
Okay, thank you.
Thank you.
Is there anything further from the public, Mr. Akris?
Any members of the public wish to give testimony, please raise your hand. Use the raise your hand function. Mr. Chairman, I see no individuals that are using the raise your hand function.
Okay. So then, on the basis of the materials contained in the charging documents, on the basis of the testimony received, the arguments presented by Mr. Priebus on behalf of the licensee, and his stipulation to the facts underlying the various charges, in the event that we, after considering his memorandum, find that the statute 12905D3 was constitutionally enacted, then I would find a violation of that statute on July 10, 2020, as well as of our Rule 4.05B on July 10, 2020. And in light of mostly in light of the recent violation, I think we have to impose a sanction if we find those violations. So as to each of these new violations, I would impose a $250 fine, and I would increase that to $650 based on the other things, for a total of $650, and give them 30 days to pay if we find the violations.
Commissioner Guy, I would also concur with that. I would find that there was a violation for the alcohol beverage Article 12905 D3, and also Rule 4.05B, prohibited hours, that took place on July the 10th, 2020. I concur with the fines as the chair laid forth, and I would concur. Thank you.
Thank you.
So based on the charging documents, the proffers from counsel, stipulation of the facts, I would concur with the chairman as to finding that after reading Senate Bill 181, that find the charge on alcoholic beverage Article 12-2005C3 is inapplicable and strike that. If we find the statute, House Bill 954 constitutional, I would find a violation of alcoholic beverages 12-905D3. And if, again, we find House Bill 954 constitutional, I too would find a violation of Rule 4.05B, prohibited hours. Mr. Chairman, just a clarification on your imposition of a fine. Are you suggesting $325 per charge?
I guess that's probably the way we should do it, because I was just adding something for the past violations, but let's do it that way. That's a better idea.
Okay, so given, just I guess for the public's own, I mean, the board's, given the pandemic, the board's been much more moderate in its fines, given the financial strain of a lot of these licensees. So I too would concur with the imposition of a $325 fine for each of those two violations, and would strongly encourage Mr. Priebus, your client, to work with Mr. Ockheimer and figure out what some of these community issues are, because it sounds like we're discussing legal issues, but there clearly is another community component that needs to be addressed. Thank you.
Thank you.
So we're going to take this matter sub curia, and I'll ask Mr. Ackles to get the commissioners copies of your memorandum as soon as he can, and to also share it with Senator McCray.
Yes, can I just make 2 points of clarification for the record, Mr. Chairman?
Yes.
Okay, first is with regard to the testimony of Senator McCray, he has every absolute right to testify in this matter. I just want to point out to the board, I don't think it's going to become a relevant issue, but it is inappropriate under case law for a member of the legislature to testify in his individual capacity as the cumulative legislative intent. So to the point, I don't think he crossed that line, but to the point that Senator McCray may have offered evidence of legislative intent, I would ask that that be stricken.
I didn't take it. He was giving us some background on the legislation.
Yes, sir. The second point, I just want a clarification from Commissioner Guy that his ruling is also sub curia, as the other two commissioners are, pending the resolution of the constitutional issue.
Yes.
Thank you, sir. Thank you. I have nothing further.
All right. Thank you, Ms. Russell.
Medical exhibits, Board Exhibit 1, investigation report. Agent Perez, Board Exhibit 2, House Bill 954, Licensee Exhibit 1, memo, legal argument.
Thank you.
Mr. Priebus, you will receive a copy of the board's decision after they review the memorandum that you sent in via mail. Okay?
Thank you, sir.
Mr. Chair, I know that we had called New Q's Liquors on its own. I know the issues are the same in case number 2, which is Eminem Lounge. And since we have Mr. Priebus here, can we call Eminem Lounge now?
Yes.
All right. Calling Myung Kim and Yongdu Park, Myeongnam Incorporated, trading as Eminem Lounge, 2500 East Biddle Street. This is a Class BD7 beer wine liquor license. Violation of Alcoholic Beverages Article 12-2005C3 on July 10, 2020. Violation of Alcoholic Beverage Article 12-905D3 on July 10, 2020. And a violation of Rule 4.05B, prohibited hours, July 10, 2020. And all of the parties that were providing testimony in the prior hearing are all related to this hearing, and they're all made panelists.
Let me ask Mr. Priebus, first identify yourself for the record, please.
I'm sorry, Mr. Chairman, I couldn't hear. There was feedback.
Would you identify yourself for the record, please?
I'm sorry. Peter Priebus on behalf of the licensee, Young Kim and Young Du Park.
Are you going to stipulate to the facts in this case as well?
Yes, sir, Mr. Chairman. All of the same identical arguments. The history may be different for this establishment than the first.
Right.
But otherwise, I would ask however you find expedient to incorporate all the arguments, and perhaps we should have consolidated the cases.
Yeah, so again, as to the 122005C3 violation, I would dismiss it for the same reasons that I found in the prior case. And as to the 12905D3 violation, as well as the 4.05B rule violation, I'd hold them sub curia until we've had a chance to review your memorandum. I would take into consideration the arguments that you made with respect to the prior case, as well as the background that was provided by Senator McCray. And I would take the case sub curia. And in the event that we find that the statute was constitutionally enacted, I would impose a sanction. But before we go there, I'd like to hear if there's public comment.
At this time, if there are any individuals that wish to provide testimony, please use the raise your hand function. Senator McCray, I know that you're still online here too. Would you like to provide any testimony in regard specifically to Eminem Lounge?
No, I'm okay. Thank you, Mr. Chair. Thank you, Mr. Akers.
And I see no other individuals that wish to give testimony, raising their hands.
All right, thank you then. As far as I am concerned, on the basis of the materials contained in the charging documents, the proper on the stipulation as to the facts that occurred on July 10, 2020 at the Eminem Lounge. In the event that we find violations of 1295D3 and Rule 4.05B, I would impose a sanction as to each of these violations. And because there are violations on this licensee, not unlike the last, I would go with the same sanction of $325 as to each violation for a total of $650, and give them 30 days to pay. And I'd like to hear from the other commissioners.
I also concur with the finding that I concur that there was a violation of the beverage Article 12-905D3, and also Rule 4.05B, prohibited hours. If it was constitutionally enacted, that the fine would be $325 for each, which would be a fine of $650 for the two. And that Article 12-205C3 be dismissed.
Based on the charging document, the stipulation of facts, the proffers from counsel, I would dismiss alcoholic beverage Article 12-2005C3. I would hold sub curia the charge on violation of alcoholic beverage 12905D3 and the violation of Rule 4.05B. If we find that House Bill 954 is constitutional, I would find a violation of alcoholic beverage 12905D3 as well. If we do find it constitutional, I'd find a violation of Rule 4.05B, prohibited hours, and would impose a fine on each of $325 for a total of $650.
Clerk call exhibits for the record. Board Exhibit 1, violation report. Agent Perez, Board Exhibit 2, House Bill 954. Exhibit 3, licensee memorandum, and 4, Senate Bill 571.
Mr. Previs, like in case number 3, the board will be mailing you correspondence as to its decision and the final outcome once your memoranda is reviewed. Mr. Previs, did you hear that?
Yes, sir. Can you hear me?
Yes, I can. Okay. Mr. Chair, at this time, we have all of the inspectors, and I know Senator McCray is still on the line for case number 1, and we can call case number 1. I see some individuals that may be here for case number 1 in terms of the licensees. So if I could just check on that, I would appreciate it. Mr. Chair, did you hear that?
Yes, that's fine.
Okay, thank you. Is this Keon Kim?
Yes.
Are you here? Which case are you here for?
With Eminem Lounge.
Okay, all right. So that case was already heard. Your attorney was present. Thank you. I appreciate that. Thank you. Anyone here on behalf of Young Suk Cho, Young's 2 Incorporated, trading as Young's 2401 East Chase Street, Young Suk Cho? If you're not speaking, please mute yourself. Young Suk Cho. This may be
legal, then it's going to be a $650 fine plus
Mr. O. Mr. O, I believe I made you a panelist. Mr. O. Mr. Chair, it seems like maybe Mr. O may be having some technical difficulties.
Is he here on case number 1?
I'm trying to verify that, sir, but his audio does not seem to be working.
Well, then let's call case number 5.
Okay, all right. Thank you. Calling case number 5, Jason Munoz, Marilyn Munoz, El Rincon, Trocanaleno, LLC, trading as El Rincon, Trocanaleno, 422 through 26 South Macon Street, to Class B beer wine liquor license, a violation of Rule 3.12, General Welfare on February 13, 2020, violation of Rule 4.14, live entertainment without authorization, February 13, 2020, violation of Rule 3.12, General Welfare, February 15, 2020, violation of Rule 4.14, live entertainment without authorization on February 15, 2020, violation of Rule 3.12, General Welfare on February 28, 2020, violation of Rule 4.14, live entertainment without authorization on February 28, 2020, and a violation of Rule 4.16, illegal conduct on July 11, 2020.
Is there counsel representing him?
Mr. Previs is
It's me, Mr.
representing.
Chairman.
Okay. And are we going to have testimony in these cases?
The licensees are present with me, Mr. Chairman. It's going to be a admission.
All right. Well, let's
with
swear
one technical argument.
Let's just swear them in for let's make sure.
Get in the screen.
I can hear. Yeah, Madam Court Reporter, your mic's on.
Okay, please raise your right hand. Thank you. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
Yes, I do.
Agent Perez, I do.
Okay. Is that everyone? All right. So, Mr. Previs, it's my understanding that the board is not prepared to proceed as to the February 13 violations, so they will be dismissed. The rest are still before the board from February 15, February 28, and July 11. Will they be admissions or denial?
There'll be admissions, Mr. Chairman. I just want to make one technical legal argument with regard to the July 11 charge.
Well, before we go to that, because that's different than the others, these entertainment violations, did you want to provide some explanation?
Yes, Mr. Chairman. Thank you very much. Right before the COVID-19 closures, I had been retained by the licensees who I've represented for a couple of years now. They had a meeting with the liquor board with regard to their live entertainment, and we actually had a game plan set up to initiate filing for the appropriate permits for live entertainment and meeting with the appropriate stakeholders to try to get that legally in place so that it would not be a further issue. We were totally shut down in that endeavor by the closures of COVID-19, and this hearing that was previously scheduled was postponed. The licensees have been cooperative, and they've been responding to me, and they are actively engaging me in order to try to get on the right track. But right now is just not a good time to get that done. All of these violations have to do with the music at the establishment, which for the old timers like me used to be Alona's in Greektown, just as you come through the underpass from the city. It is on Eastern Avenue in a commercial area, and they are eligible to get on the right track. We just haven't had sufficient time under the circumstances to do so.
Well, I have a question for you, Mr. Priebus. I mean, these violations occurred before the COVID-19 shutdown, but why were your clients going ahead with the live entertainment before they were able to alter their license?
Honestly, Mr. Chairman, I believe it's a bit of a cultural issue with regard, and I don't say that lightly, as far as getting on track and having a lawyer be involved in your process. It's quite frankly been a bit of education with Mr. Munoz, but he has come on board, and I believe I am in control of the situation now once I'm able to do what I need to do. So,
okay.
With
right.
total candor, that's kind of where it stands.
I appreciate that. Now, you wanted to make an argument as to the COVID violation on July 11. Before you do that, I wanted to point out to you that we are proceeding with this on the basis of the governor's executive order only.
Yes, sir. And having stayed in my office till 11 o'clock at night for the last several nights on the prior issue, I have not done a comprehensive review of the appropriate laws. I just note for the record that I believe that the governor's order, and I am 100% behind the governor's order, and I take this COVID situation extremely seriously, as we all do. But I believe that it would require actual legislation to have the teeth of law and enforcement power. My clients, I have spoken with them, and they do intend to comply going forward. But I'd throw that legal argument out there and submit at that.
I have the same concern, Mr. Priebus, but I'm advised that the executive order does authorize us to enforce it pursuant to our rules. So with that understanding, I will accept the admission of the violation. Okay. So before we go further, do the other commissioners have questions?
After the first set of violations on February the 13th, and then we have the 15th and the February the 15th, February the 28th, in sync. My question is, after the first set of violations, is there anything that caused them to continue? You know, it just seems like there wasn't a concern after the first set of violations.
Mr. Commissioner, there is a concern, and there was actually not only on-site meetings with the liquor inspectors, but a meeting at the liquor board and a meeting with Mr. Ockheimer, and I was called into that meeting. There are two violations here. One has to do with noise, and the other has to do with getting the proper permit for the live entertainment. We dealt with the fact that there has to be appropriate application for a use permit for the live entertainment. It's authorized but not obtained, and we would have to deal with that, having to do with DJ, which is technically considered live entertainment under the city ordinance and the liquor board rules. The other issue is music coming out. It is a commercial area, but behind that area are the small side streets of Greektown that have residences, and we take responsibility, but it appears to be one caller that keeps calling, and a lot of times it's not here, but there are other unfounded complaints, as you saw on the July 11. Yes, they are licensees, and yes, they have to take their responsibilities very seriously, and we do. And we discussed soundproofing and other measures that have to be addressed. The premises has been ongoing. Steps need to be taken going forward, and we do agree with that. It's not an issue of thumbing your nose at the law. It's an issue of continuing in business and trying to survive in business, and at the same time making improvements as you go.
Okay.
And Mr. Chairman, I don't have any questions. Just I hope, Mr. Priebus, that your clients understand that they do need to listen to you and need to get in line, because this is not a good record, and these certainly aren't good charges. So, absolutely, that's a pattern. But thank you.
Did the agent get cooperation?
Agent Perez?
Didn't get your question, sir.
Were they cooperative with you, the agents?
Yes, they were.
Okay. Mr. Akras, do we have public comment?
At this time, if there are any individuals that wish to provide public comment in this case, please use the raise your hand function so that you can provide testimony. Let me just make sure. I think I've got someone from Greektown, but I just want to be sure. Ms. Brooke? Okay, I don't think anybody wants to give. I'm not seeing anybody that is using the raise your. Ms. Brooke, did you want to give testimony?
Thank you. Hi, I have nothing to add, but thank you for asking.
Okay, all right, thank you. Mr. Chair, I see no individuals that wish to give testimony in this case.
All right, thank you. Mr. Priebus, then on the basis of the material charging, on the basis of the admissions that you entered on behalf of your client as to the February 15, February 28, and July 11 violations, I would make the following findings. I would dismiss the February 13th violation as to Rule 312. I would dismiss the February 13 violation as to Rule 414. As to the February 15 violations of 312 and 414, I would find those violations and impose a $125 fine as to each. As to the February 28th violations of 312 and 414, I would find those violations and impose a $125 sanction as to each. As to the COVID violation of our Rule 4.16 on July 11, 2020, I would find the violation and impose a $150 fine. So that's a total of $650, and I give them 30 days to pay. And that's based in part on the record, which is not good, as Commissioner Greenfield said, but also giving some consideration to our unique circumstances at the present time. Commissioners?
Commissioner Guy, I would concur with that. I find the violation of Rule 3.12, General Welfare, on February the 15th. Violation of Rule 4.14, live entertainment without authorization, on February the 15th. Violation of Rule 3.12, General Welfare, February the 28th. Violation of Rule 4.14, live entertainment without authorization, February the 28th. I will concur with a fine of $125 for each one of those violations. and also for violation Rule 4.16, illegal conduct on July the 11th, 2020. I concur with the fine of $150.
Thank you.
So I find the following, I find dismissal, would dismiss Rule 3.12 on February 13th, would dismiss the violation of Rule 4.14 on February 13th. I find a violation of Rule 3.12 and would impose a fine of $125. I find a violation of Rule 4.14 on February 15th and find a violation and would impose a violation of $125. Find a violation of Rule 3.12 on February 28th and would impose a fine of $125. Find a violation of Rule 4.14 on February 28th and also impose a $125 fine. And as to Rule 4.16, I find a violation on July 11th, 2020. This is obviously a really serious violation, and this one being his first and hopefully his only, I too would concur at this point for the fine of $150.
Thank you, Ms. Russell.
Like call exhibits for the record. Board Exhibit 1, violation report, Agent Martin. Exhibit number 2, 311 complaint database printout. 3, violation report, Agent Perez. 4, 311 complaint database printout. 5, violation report, Agent Tudhope. 6, 311 complaint printout. 7, violation report, Agent Perez. 8, mayor's executive order, and 9, governor's executive order.
Mr. Priebus, like in similar rulings, the board will be mailing you correspondence detailing the board's decision.
Thank you very much, Mr. Akris, and thank you to the board for your very generous considerations.
Thank you. You're welcome.
Mr. Chair, we have one more case on the docket, and that is case number 1.
Let's call it.
And I'll call it now. Young Suk Cho, Young's 2 Incorporated, trading as Young's 2401 East Chase Street. There's a class BD7 beer, wine, and liquor license. A violation of Alcoholic Beverages Article 12-2005C3 on July 11th, 2020. A violation of Alcoholic Beverages Article 12-905D3 on July 11th, 2020. And a violation of Rule 4.05B, prohibited hours, July 11th, 2020. Mr. Chair, if you don't mind, I'm just going to check all the attendees to see if any of them are going to be giving testimony in this matter.
Please do.
Yes, this is calling user number 5. I was just seeing if you were going to be giving testimony on Young's 2401 Chase Street. I've unmuted you. You're just on the phone. Okay. Mr. Thrasher, I am just reaching out to you to see if you're going to be giving testimony on Young's 2401 East Chase Street.
Yes, I'm here on behalf. Yes, I'm here on behalf of Young's. What's wrong with speaking?
You are here on behalf of the licensee?
Yes.
Okay, I'm going to pull you in and make you a panelist. Stephen Zadiria, Mr. Zadiria, are you here on behalf of Young's?
No.
You are not. Okay. And Inspector Washington, I have you here. Are you participating in Young's? This is 2401 East Chase Street. Inspector Washington. Okay. All right. I believe I pulled all those parties in. Mr. Thrasher, can you please turn on your video footage?
Can we swear this gentleman in, please?
Okay.
Should be Devon Thrasher. His video footage is on.
Okay. Please raise your right hand. Okay. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
Yes, I do.
Agent Perez.
Okay, Mr. Thrasher, this is the chairman. Can you tell us who you are, please?
Yes, I'm the manager at Young's
Okay.
Incorporated.
And you have been on this video for the other cases as well, I take it?
Yes.
Okay, so you heard the discussion on cases 2 and 3 of identical charges to those that are made in this case?
Yes, sir.
Okay, so because of the rulings that we made in those cases, I think that we are bound to do the same with respect to this one, and that is the July 11 charge for a violation of 12-2005C3 will be dismissed, I believe, and the other 2 charges from July 11, 12905D3 and Rule 4.05B, we will hold sub curia until we've had an opportunity to review the memorandum of law and consider that, as well as the testimony that we heard from Senator McCray about the statutory enactment. Did you understand that?
Yes, sir.
Okay. Let me see if the other commissioners are in agreement with that.
I concur.
Yes, I agree.
Mr. Akers, do we have public comment on this case?
If there are any individuals at this time that would like to give public comment, testimony in regards to this case, please use the raise your hand function. Mr. Chair, I see no individuals that wish to give testimony in this matter.
Okay. So, Mr. Thrasher, I didn't want to cut you off. Was there anything that you wanted to add?
No, sir.
Okay. Well, in the event that we find that the statute is lawful, and we find that there were these July 11 violations of the 2 charges, 12905B3 and Rule 405B, I will be imposing sanctions. Your record is better than that of the others, so I would impose a sanction of $150 as to each for a total of $300 and give you 30 days to pay if we find that. If we find that it's not lawful, there will not be a fine. Commissioner?
Commissioner Guy, I concur with the findings that the violation of alcohol beverage Article 12-905D3 took place on July the 11th, and violation rule 4.05B prohibited hours also on July the 11th, that the fine would be $150 if we find that the constitutionality is enacted, and that also the violation of beverage Article 12-205C3 be dismissed.
Thank you.
So I find I too would dismiss alcoholic beverage Article 12-2005C3 on July 11, 2020. If we find House Bill 954 constitutional, I too would find a violation of alcoholic beverage 12-905D3 and would impose a fine of $150. Again, if we find the legislation to be constitutional, I would find a violation of Rule 4.05B on July 11, 2020, and impose a $150 fine, and we're going to hold these 2 matters sub curia. Mr. Thrasher, we did receive a number of letters about some community concerns, and I would encourage you to connect with our community liaison, because we received some letters and just want to make sure that you're addressing whatever those concerns are.
Yes, sir.
Michael Exhibits for the record. Board Exhibit 1, Violation Report, Agent Perez. Exhibit number 2, House Bill 954. Exhibit number 3, letter from Stephanie Smith, Chair of City House of Delegation. Exhibit number 4, letter from Councilwoman Shannon Sneed. Exhibit number 5, letter from Senator Corey McCray.
Thank you.
Mr. Thrasher, we're going to be mailing this correspondence to the establishment regarding the board's decision once they may review the memorandum.
Okay. Mr. Akers, before we conclude the hearings, I'd like to say to the other commissioners that I would appreciate having their thoughts on the memorandum once they've had a chance to take a look at it. And I believe that's our docket for today.
That is correct. The board will be in recess until Thursday, August 6th at 11 a.m.
Thank you.
Thank you.